I said that my name's Sabrina, and with me is Andrew. So we're both lawyers at the Auckland Community Law Centre. I'm also a legal educator at the Auckland Community Law Centre, which is pretty much what we're doing today. The presentation we're giving today is for information only. This isn't legal advice. So we'd really recommend anyone who's listening who has kind of very specific questions that they seek legal advice, because we're going to be giving general information, and I think it's really important that if you have kind of questions that are related to your organisation, you really should seek specific legal advice, just to make sure that everything's covered. Okay. Yeah. Just basically what this session is going to cover is we're going to look at the incorporation process. We're going to look at kind of how charities work. We're going to look at tax exemption, liability, which is a question that we noticed came up quite a bit in those registrations. And then we'll look at questions, which Sam's going to help us with. So the first step is the incorporation process. There's many of you might be aware, there's kind of two main kind of incorporated bodies or organizational structures. The first of those is an incorporated society. As of now, an incorporated society is a membership-based organization that was registered under the Incorporated Societies Act 1908. As we're going to touch on very shortly, there is a new act that has very, very recently come into force that does change some things, and we're going to look at some of those changes and how they might impact a lot of you guys in your work. So to register as incorporated society, you need to be able to show that you exist as a group for a lawful purpose, and that purpose must be other than making a profit. Another kind of core kind of point for incorporated societies is that the key decision makers are accountable to a large membership and are elected, and they can actually be removed by members. So that's your typical kind of officers of the society.
Yeah, a couple of comments on that. So that first issue of groups existing for purposes other than making a profit, sometimes people are confused by the fact that income can be generated as opposed to a profit in the hands of, say, officers of the society. So it's really where that income is paid to for the furtherance of the aims of the society, rather than being paid out to any members or officers of that society. So it's entirely possible, of course, to generate income, but profit in the sense of payment to individuals who are members is what is not contemplated. The other issue is, I think, the contrast between incorporated societies and charitable trusts, and sports clubs and cultural groups may well be one or the other. It's entirely possible to choose which structure you want. I'd make the general comment that probably incorporated societies are seen as a more open and democratic model where members can actually be involved in the fundamental decision making of the organisation. Charitable trusts, on the other hand, are run by trust boards who will operate the trust for the benefit of a section of the public, and that section of the public won't get to have a say in how that trust runs. The trust must operate for its benefit, but there's no direct input. So there's quite a contrast in how organisations are run, and that may be one defining factor as to whether you want a more democratic and possibly larger organisation or a smaller and more tightly controlled organisation. But as I say, sports clubs could possibly, depending on their purposes, operate on both models. Community law centres, for example, generally charitable groups, but half of them in New Zealand are trusts, and others, the other half's incorporated societies. So different models for different organisations doing exactly the same thing.
Yeah, all right. So coming, I guess, to some of the more practical stuff. So when you register under the Incorporated Societies Act, you become an incorporated body, and you have your own, or the society will have its own legal identity, and that kind of will play into issues like liability, which we're going to touch on a bit later, how that compares with an unincorporated group, for example, and how personal liability might play out in those different kind of areas. really important point is that the activities of the society are limited by the Incorporated Societies Act and the rules the society adopts for itself. So it's really important that the rules comply with those set out in the Act, and that any directors, or not sorry, directors, but officers of the society comply with both the rules and any restrictions set out by the Act. And that's where kind of some of the new laws put in place by the updating 2022 Act are going to be a bit more detailed in terms of some of those responsibilities.
So just stripping that one back to basics. So one of the key advantages of incorporation, either as an incorporated society or a charitable trust, very much the same as with companies which are set up to make profits. The idea of separate legal entity apart from, say, members, trustees, in the case of companies, that'll be directors and shareholders, a separate entity, and also what's called perpetual succession. So that group will continue on even though members or trustees may depart the organisation. So that's a really fundamental aspect of charitable trusts and incorporated societies, separate entity, perpetual succession.
Yeah, I think we'll definitely touch on that a bit more as well going forward. So the minimum membership of an incorporated society needs to be at least 15 members, but I believe that has been changed by the new Act. The society must also have a kind of, the rules need to meet the requirement under the Incorporated Societies Act. So, the rules can, be obviously distinctive to the society as long as they meet those requirements. You can't be in breach of those requirements.
Just a comment on that. So there is a compliant template rules builder on the registrar, and this is the Registrar of Incorporated Societies on that website. So you can build a set of rules using what is currently a compliant model rules. There is, as Sabrina's talked about, changes in the legislation happening, and I would imagine that template is going to have to be substantially updated. At the moment, though, the current 1908 Act, is in force, and there is a template if you're considering setting up a society at this point.
Yeah, and we'll touch on what's going to also happen for older societies with the new Act as well, because there's going to be some changes, obviously, and rules might need to be updated to actually be compliant with the new Act. But yeah, the main things the rules actually need to cover is the objects of the society, how a person becomes and stops becoming a member, how general meetings are going to be called and held, and how voting is actually going to take place at those meetings, how the officers of the society are going to be appointed, your executive, and kind of how the society's funds are going to be controlled and kind of invested, and what are the kind of powers of the society to borrow funds, for example, to kind of carry out its activities. And I think a very crucial one is how the rules can be changed, which is a really important kind of thing to cover in terms of the functioning of the society. In terms of that, moving forward, you need to have a clear kind of roadmap, I suppose, on how those things can happen.
Very important when you are setting out your rules. Probably the most important thing is to outline your objects and purposes. So that really sets the boundaries of what the group will do into the future. So, and this is the same with charitable trusts. You really need to do a bit of future gazing as to what you think the organisation will be doing in the future, as well as at the time the organisation is set up. It can be a difficult exercise, and purposes and objects can be changed, but it's best to be thinking ahead quite some time as to what you consider the organisation will do in the future, because there are legal issues with decisions which operate outside the rules, and that includes objects and purposes for which both incorporated societies and charitable trusts are set up. So must operate within those purposes as well as the general mechanical things in the rules.
Yeah, and I also believe the registrar can give actually written notice to the society if they're acting outside of their objects, and they can actually be issued a fine for every day the kind of breach continues. And I'll note that, you know, for example, if a society enters into a contract that actually sits outside of its objects, that transaction could be considered invalid, and then not enforceable against the society, but it actually might be held, might be enforceable against the officers.
Yes, we've entered into that contract, so that would be one of those rare, I suppose, instances where personal liability, so for, in this case, officers of an incorporated society entering into contracts outside the purposes of that organisation. So it's always really a very basic first principle that officers of the society, trustees of a trust, really need to be on board with what is in their rules and their deed of trust. You know, that fundamental understanding of what the organisation is there to do.
Absolutely. So yeah, now we're going to talk a bit about the new Act. So this is the Incorporated Societies Act 2022. So currently incorporated societies registered under the 1908 Act will not need to do anything right now. But once, I believe when they re-register, that's when it's going to kick in and they're going to have to make their rules compliant.
What needs to happen, and it hasn't happened at the moment, is that there are regulations which sit underneath the Act, which is really the donkey work law, and those regulations haven't been passed by Parliament yet. And so until that happens, nothing's going to happen for existing organisations, but is expected that sometime after October this year, hopefully those regulations will be in place. We can't comment about what's in them, but there's going to be a process of over 2.5 years. So it's taking us into 2020, I think up, or could be as far as 2026, that period by which existing incorporated societies are going to have to re-register, and that's going to involve compliance with the more detailed obligations under the new Act. But there is nothing to actually do at the current time other than note the changes that are coming.
And start preparing, thinking about how you're going to meet those changes. And here we've done a little bit of a slides to kind of show some of those key changes. So as I noted before, there's going to be a new minimum of 10 members, which is quite a good one, because I mean it means you can kind of look at incorporating with less people. Another really key change is that societies are going to be required to have adequate dispute resolution procedures, and these will be specified in the Constitution.
Can I just jump in there? In a lot of work that I've done with not-for-profits, there's frequently been internal disputes in organisations, and there's been no way of easily deciding those matters other than, say, calling special general meetings or that sort of thing, which is quite a large sort of meeting and process. There is in the new Act a model complaints and dispute resolution process which organisations can adopt without modification, and that will be seen to be legally compliant. But you will be able to work out your own complaints and dispute resolution procedures as well. So provided you actually have one, is probably the main thing. It needs to be in there now. It's not up to the organisation as to whether there's a formal process. You will have to have a way of dealing formally with complaints and resolving disputes within the organisation.
Yeah, and another kind of few things is, yeah, just considering that you will be required to have committees of at least 3 members going forward. And I think one of the other really key changes is officers are going to have really clearly defined duties, unlike previously where it was quite a bit loose, I would say. There was no kind of clear duties there, no kind of clear guidance. Now there's a lot more, yes, there's a lot of clarity has come through with the new Act, and there are now kind of a lot of those duties are very similar to those of company directors. And yeah, there are some requirements as well for who would qualify as an officer, and those are actually quite similar as well to who would be able to qualify as a company director, being over the age of 16, you cannot be undischarged, bankrupt, things like that. So
having convictions for criminal dishonesty. So the duties are going to be to act in good faith, pursuant to the rules, to show reasonable care. These are very broad duties, but they were not in the old law. It's one of the reasons for an update. It brings, I guess, not-for-profit organisations more into line with the expectations of company directors. So a little bit more detail in the law than previously. But nothing, I don't think, hugely onerous. You've just got to be thinking that doing things outside your rules, grossly negligent or dishonest, fraudulent acts or illegal activities are the sort of acts which you won't be able to do without some personal liability.
And yeah, more of an administrative thing, but annual general meetings will also, under the new act, they'll need to be held within 6 months of the society's financial year. So that's just kind of putting clear guidance in place and how often those need to be held, whereas before it was a bit unclear and there was no specific guidance on those AGMs or any meetings. Right, and yeah, still a few more. So another change will be that financial statements will need to be filed with the registrar within 6 months of the society's financial year ending. So I guess you can probably see there's a bit of a theme here where the 1908 Act was silent on some things or was not clear on some things. The new Act is kind of putting some very clear guidance with these kind of things. So financial statements before was kind of annually, now it's kind of a defined time for that to be done. Society is now required. Sorry about the background noise. We're in the city. Sorry about that. So sorry, with the 2022 Act, you will kind of need to be using XRB accounting standards, which I think Andrew can tell you a little bit more about.
XRB is the External Reporting Board. So that's actually a government accounting directions body. So those are governmental standards that sort of talk about financial reviews and auditing by and large. So it's the standards that you have to meet. So that's set by the External Reporting Boards. The references in the new Act to another governmental organisation which deals with accounting standards, audits, reviews.
Yeah, and another change will be that when the organisation winds up, surplus assets have to be given to a not-for-profit organisation, unlike previously where it could be given to any party. I think it's quite obvious why that is. You know, you want to make sure that a charitable organisation doesn't just build up kind of assets and then gives them to a possible non-charitable organisation.
Well, previously, members of incorporated societies might benefit on the winding up of a society. So now that won't be the case. And you will have to, in your rules, if you're an incorporated society, set out either a specific organisation or a specific charitable or sector of, say, a sport. So that might be to other, say, amateur rugby clubs in the Auckland region, or something along those lines, or to a specific club. That's the sort of thing you'll need to actually outline. And
amalgamations can also take place for two or more societies under the new Act. There was no real legislative framework before. Now there is a framework in place. It's as outlined in the Companies Act, but it's a bit more simplified than that. Companies Act is really our expertise, but yeah, it's just something to bear in mind. Also, you know, as we've mentioned before, new criminal offences will be put in place targeting kind of egregious conduct. That might seem a bit scary, but you know, it is egregious. So kind of examples of that could be making a false statement. It could be fraudulent use or destruction of property. It could be falsification of documents, defrauding of creditors, improper use of the word incorporated, or breaching of the banning order. So, you know, I don't think it's something a lot of people are going to have an issue with. It is to target kind of those people who are kind of taking advantage of societies, you know, for their own benefit in a lot of these cases. Another change will just be that members will need to consent to becoming a member of a society.
And that probably happens in most cases, particularly if you're a sports club and you have a roll of members and people pay an annual sub. I'm a member of a bowling club. Well, basically, when I pay my annual sub, that'll be seen to be consent. Okay, so it's not as though you have to be asking questions about do you consent. It's just going to be the process requires input and engagement from members. They can't sort of become de facto members accidentally just by perhaps coming along to a club. There's going to have to be a process there which ensures that people are aware of their membership.
Yeah, and it's, you know, a society can kind of determine how they're going to get consent, and it doesn't have to be, like Andrew said, it doesn't have to be something very complicated or legalese. It just has to be, you know, something like a membership form could do the trick, because that's something that that person has completed. It's just, I think, more so people can't just claim people as members of the organization. They might not be. So it's up for kind of each society to determine how they're going to manage that. Yeah, I think that's probably the main changes that should really be considered, and yeah, for a lot of you should turn your minds to how you know, you're going to be able to meet those. But like Andrew said, it's probably a long time coming before any substantive changes need to be made.
Yeah, the new Act broadly brings incorporated societies into line with another piece of legislation, which is the Charities Act. Okay, and we're going to talk about that next. But the 1908 Act was very, well, I should say very old, not probably fit for purpose in terms of modern ways of operating. You know, well, you can say that many societies are operating as businesses and really lacking in a lot of detail. Things such as the requirements for reviews and audits of annual accounts for larger societies are in line with the requirements of the Charities Act. And we'll talk about that fairly shortly.